Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. And whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Hey there. Well, good morning, everyone. Welcome to the Bottled Business Sense show. I am Moscoso, one of your co-hosts here this morning. And just want to welcome everybody from Facebook and YouTube. Of course, you can watch us on either of those platforms, as well as LinkedIn, Twitter, and, of course, iTunes. So if you are a audio consumer, then you can always go over to our channel on iTunes, download this, rate us, review us, download. That would be great. Or visit our website, of course, at any time you want at bottlebusinesssenseshow.com. So anyway, today I'm going to bring on my co-host Bill Bernard here in a second, and he's going to speak on a topic centered around employment law. But before we do that, let's welcome Bill here to the show. And how you doing, Bill?
Pretty good, Rick. And you?
I'm doing great.
Good. I'm glad to hear it. That's what I want to hear. I want to hear that from everybody out there. A couple of commercials before we get started. Believe it or not, we every once in a while we're going to do commercials. Nobody pays us for this. This is just tips that I try to bring to you that I find interesting or I like, and I think maybe you might too. So you can take a few notes and say, yeah, I'd like to try that, or I'd like to check that out, or you can just say, nope, let's get to the show, Bill, and eventually I will. Couple of things. My brother turned me on, especially because of COVID, my brother turned me on to this place called wine.com. Just like it sounds, WINE.com. And it ships really good California wines. I'm a big California wine fan. I like to go to the wine country all the time. Haven't been able to do that since COVID. But wine.com gives you a very, very good selection of premium California wines. And I'm kind of picky, so it doesn't have every winery I like, but it has a large majority of what I like. And you can order from them, and especially, shipping really gets you. I know shipping to Hawaii is like between $70 and $100. You pay $50 to wine.com a year, and you get free shipping no matter where you are. And they send you this pamphlet that comes with the shipment, and they always send you a 10% off coupon and a $20 off coupon. These are good till April, so you got plenty of time to use them if you want to buy more. But I just think it's a really cool place because you order directly from the wineries, and boy, you really get killed in shipping. But this is a really good deal, and if you're going to order more than once, it pays for itself because you pay that $50. You're not going to get wine shipped to you for $50 anywhere that I know of. Premium wine, good wine, and you pay the $50 a year, and you're good to go, and you get the wine shipped right to your door. That's number one. Number two. We are going to have a watch. My affinity, one of my affinities, my hobby is watches, timepieces. And so we get together with a group of guys, and sometimes we have watch shows. Well, in case you're interested, because I'm going to be selling a lot of watches on this next show, Saturday, February 13th at 1 o'clock, it's Pacific time, 4 o'clock Eastern time. We're going to be having a watch show with a number of guys that are in the group, and we're going to be showing watches and selling watches for very, very reasonable prices. So if you like those kinds of things, or if you need a gift or a Valentine's Day deal or whatever, check us out. It's Saturday, February 13th. And as I said, it comes on 1 o'clock, and it's on my site, which is FB, F as in Frank, B as in boy, Watch Forum, FB Watch Forum, and that's a page on Facebook. So you just go to Facebook and punch in FB Watch Forum. That'll come up, and Rick will have the show posted, right, Rick?
Yeah, I'm going to post the link in the comments, so all you have to do is click on the link and check it out.
Okay. So I wanted to get those two things out of the way. In addition, tell you that a lot of times we'll do recaps of things we've done previously on shows, because we get calls or we get notes or emails or something that asks us about a specific topic. So I want to go over two very, very important topics, which is the ban the box law, consider when an employer, when he can and can't consider prior convictions for hiring purposes, and also hostile work environment, which I just want to nail down very, very quickly. So we're going to recap those. They're very, very important to the employment relationship. In other words, these are things that the employer and the employee need to know and need to follow. So we're going to do that. And remember, you can always go back and watch shows that are totally on a specific subject, and then take some notes, and you're good to go. Remember that this is general law, legal principles that won't necessarily apply to any specific situation you may have as that situation interacts with these areas of law. You should go visit with a lawyer, find out specifically whether or not you have a viable claim if you have concerns about the adaptation of these laws to anything that you might be going through. Okay, so having said that, let's delve into this, and let's generally point out that you are an at-will employee in California unless you have an employment contract or agreement of some sort to the contrary with your employer, which specifies specific reasons for your termination and your job duties. So in other words, an at-will employee, you can be fired for any reason or no reason at all. And of course, you can quit your job anytime you want. So with that in mind, prior to January 1st of 2018, an employer could terminate an employee or rescind an employment offer if it became clear that the employee had a conviction on their record. In other words, that conviction threw you into the already existing employment at will situation, as opposed to being an exception to being fired or not being given an opportunity to be offered a job, I should say, as a consequence of that conviction. On January 1st, 2018, the California legislature passed Ban the Box Law, which went into effect then, and it basically involves 5 steps. So if you need to write these down, you should. If you need to go back and listen to the show again, listen to it, stop it, and whenever you need to, and take some notes. So the first step, I like to call these steps, you may call them something else, but here's how we analyze this. Step 1, under the new law, Ban the Box, an employer with at least 5 employees, an employer with at least 5 employees cannot include on any application for employment any question that seeks the disclosure of an applicant's conviction history. You can't have a question on there that asks about that. You also can ask about or consider a conviction history of an applicant. You cannot consider the conviction history of an applicant before the applicant receives a conditional offer. So in other words, you may be wanting to offer somebody a job, and you can offer them the job and then do the background check, and we'll get to that in a moment. But you can't basically say, because of a conviction history, I'm not even going to consider you. So you look at somebody, you may want to give them a conditional offer of employment under the condition that they pass a background check. And you cannot, an employer that is, cannot consider, distribute, or disseminate information while conducting this background check that in connection with any application of employment, an arrest that did, with regard to an arrest that did not result in a conviction, a referral or participation to pretrial post-diversion programs like drug programs, or convictions that have been sealed, dismissed, expunged, or statutorily eradicated. So, step one, an employer cannot include on any application for employment any question that seeks disclosure of someone's conviction history. 2, he cannot ask or consider the conviction history before making a conditional offer. And 3, even when a conviction history or a background check is conducted, the employer cannot make the application for employment referred. It cannot refer or participate in pretrial, post-trial proceedings or any kind of expungement of a conviction. The employer cannot disseminate that information. So even though the background check is going on, that information can't be disseminated. It's a somewhat complicated law, but if you listen carefully and you go back and take some notes, I think you'll be able to understand it pretty easily. Step 2, okay, consideration of an applicant's criminal history is permitted after the conditional offer of employment. Okay, once the offer has been made, the employer cannot deny an applicant a position solely or in part because of a conviction history until the employer performs an individualized assessment. What is that assessment comprised of? 1, the nature and gravity of the offense. How serious is it? 2, the time that has passed since the offense was committed. And 3, the nature of the job sought. For example, you might have a job that particularly involves a certain characteristic of trust, and maybe this crime involved a betrayal of trust, fraud, for example. That may give weight to the consideration the employer will give that particular conviction in deciding whether you fit the mold for this job. So step 2 is, now the background check is done. If the employer has to make an individualized assessment because he's not sure he wants to hire you, he must give weight to the gravity of the offense, the time since the offense was committed, and the nature of the job that you're applying for. That's step 2. Now the background check has been done. Let's go to step 3. Step 3, once the employer makes a preliminary decision that the applicant's conviction history is disqualifying, then the employer must notify the applicant in writing of the disqualifying conviction. The employer must include a copy of the conviction history report, and the employer must provide an explanation that the applicant has the right to respond to the notice within 5 business days, which includes providing the employer with supporting evidence that disputes the conviction in some way, some mitigating circumstance, perhaps. You've gone through rehabilitation, or there's information about the conviction that the employer doesn't have and you know about. So the employer now decides, based on the background check, we don't want this person. He has to notify the employee, prospective employee, in writing, saying essentially, excuse me, you have 5 days to dispute this. Here's the reason for the disqualifying situation. And within that 5 business days, of course, you have a right to not appeal, but dispute it by providing excess or in additional evidence that maybe the employer doesn't have. And he must provide you with a copy of the conviction that he's relying upon to disqualify you from the job. Let's go to step 4. The employer cannot make any final determination based on this conviction history during this 5 business day period. If the applicant timely notifies the employer in writing that they are disputing the conviction history and is taking steps to obtain evidence to support this, the employer must then provide an additional 5 business days. So the employee is essentially saying, the prospective employee is essentially saying, I need time to accumulate this other stuff, which I'm going to send you. And I think this will help you in your decision-making process. Now you got to grant the prospective employee an additional 5 days. So that's 10 days total, right? And let's go to finally step 5. If the employer decides to deny an applicant a conviction, now based on everything that he or she has at his or her disposal, the employer must then again notify the applicant in writing, which includes a notification that the applicant has a right to file a complaint with the Department of Fair Employment and Housing if he or she, the applicant, thinks that he or she is being wronged. Okay, so you basically have a 5-step process under the span the box law. No questions on an application. I'm going to highlight these now. 2, you conduct a background check, and you then must decide if you find something, the nature and gravity, the time since the conviction, the nature of the job sought. 3rd step, you must notify the individual in writing if you're going to disqualify him or her and give them 5 business days to respond. Step 4, the applicant has an additional 5 days if he or she notifies you in writing, the employer in writing, that he or she wants to accumulate some additional information to help you make your decision. And step 5, if all of that happens and the employer still wants to deny employment or withdraw the conditional offer that was offered based on the background check being conducted, then that employer must notify the applicant that he or she has a right to file a complaint with the Department of Fair Employment and Housing. Okay? So it's a mouthful, but if you go back and you listen and take some notes, this is important for a lot of people who are trying to get jobs after they've had some problems. And I can't tell you how many times this question comes up on multiple sites that I belong to where people ask these general questions. Now I want to jump over, if I could, to a area that is near and dear to Rick's heart, and that's harassment, because I harass him all the time. But we're going to talk about hostile work environment. So think of a chart. Put at the top of the chart, hostile work environment. Okay? And then we're going to draw a line down from there and bring it into 2 different brackets. Okay? So here we go. Hostile work environment, generally described as inappropriate behavior in the workplace that is either severe or pervasive enough to create an abusive work atmosphere for one or more employees. Severe or pervasive enough to create an abusive work atmosphere for one or more employees. Not a one-time thing. Okay? Hostile work harassment may be sexual or gender-based, but it may also be non-sexual harassment, such as harassment based on race, ethnicity, religious harassment, disability harassment, etc. So here's where we want to look at that chart. Hostile work environment at the top. Simply put, hostile work environment occurs when someone in the workplace mistreats another person based on their gender, race, national origin, sexual orientation, disability, those types of things, in a way that falls outside the job description of the person committing the harassing offense. So, hostile work environment. Bracket comes down. It can be sexual or gender-based. Another bracket comes off the right. That can be for other reasons, such as religion, disability, etc. So you have someone harassing you in the workplace based on gender or religion or disability. They're harassing you, and that is not part of their, in other words, they're harassing you in a way that is not within their job description. It could be a fellow employee. No harassment is ever within any job description. Don't get me wrong. But what I mean is this could be a fellow employee or someone in the workplace that's harassing you. Okay, so hostile work environment. To the left, sexual or gender-based harassment. And to the right, other types of harassment, such as religion, disability, race, that sort of thing. Now draw another bracket down in the middle, and we're going to have branch off. We're going to talk about harassment, which we just did, and on the right-hand side is discrimination. What happens when you get discriminated against in your employment setting? This occurs when an employer or supervisor treats different employees differently on the basis of the prohibited categories that we mentioned, while they're performing acts that are part of their job description. Okay? This could include demotion, termination, or discipline of some sort. So the hostile work environment is based on harassment and discrimination. And then you have different types of harassment and different types of discrimination, right? You've got harassment that can occur in the workplace that has to do with fellow employees, and you can have harassment and discrimination occurring in the workplace by a supervisor or your boss. So these are important things to remember. Let me read this again. Hostile work environment harassment occurs when someone in the workplace mistreats another person based on their gender, race, national origin, sexual orientation, disability, etc., in a way that falls outside the job description of the person committing the harassing. Okay? They're just a fellow employee. In contrast, employment discrimination occurs when an employer or supervisor treats different employees differently on the basis of these prohibited categories while performing acts that are part of the job description of the person committing the discrimination. It is the boss's job to tell you what to do. He's doing so, but he's committing, he or she, discrimination or harassing behavior in the process. So think of a hostile work environment as being composed of harassment in the workplace and discrimination in the workplace. They're two different things. Harassment can be completed by or done by a fellow employee. Discrimination or harassment can be done by a supervisor or a boss. Okay, so keep those things in mind because the final point I want to end on, which is not harassing behavior or discriminatory behavior, is this. Being nasty, showing favoritism, or simply being unfair does not constitute a violation of law. Remember that a lack of character or integrity, broken promises, that sort of thing, being a jerk, that type of a boss or individual in the workplace is not something that rises to the level of a hostile work environment that we just discussed, composed of harassing behavior and discriminatory behavior. So that only rises to the level of illegal behavior if the being nasty or being a bully, in other words, being a jerk, if that also involves some discriminatory category that we talked about. Then it jumps into the harassing or discrimination category, depending on what it is and who's doing it. But if it's just being a nasty person, that doesn't rise to the level of an actionable claim. Okay, so that should do it for today's show. I know it was a rather quick, loaded recap. I hope you can take some time to go back and look at it. Remember that we are on, one thing I did want to mention as well, we are on iTunes. So if you go to iTunes and you punch us in, you'll be able to download episodes, rate us, tell us how good you think we are, that sort of thing. And real quick, Rick, where do they go to find our iTunes broadcast?
Yeah, you can just go to iTunes and just search for Bottled Business Sense Show. I will have a link. I'm adding a few things to our Bottled Business Show website, some updates, so there'll be a direct link there. But what I'm going to try and do is have everything in our profile, Facebook, YouTube, Twitter, LinkedIn, that cross points to all of our other platforms where you can listen to us, like iTunes. So that'll be updated shortly. But again, Go ahead.
I was going to say the reason I shot it back over to you to tell them where to do this is because my understanding, correct me if I'm wrong, once you go to once you go to iTunes, there's a couple of different boxes that you have to, once you locate Bottle Business Sense Show, there's a couple of things you have to do in order to actually download the episode, right? It's just not, you just don't click on Bottle Business Sense Show. Is that correct?
All you have to do is subscribe. If you have if you go to iTunes Podcast, they call it now. If you go to iTunes Podcast, there's already a built-in app, and if you don't have it on Android or an iOS device, it'll prompt you to do so, and then you search for Bottle Business Sense Show. Subscribe to the channel, and then you'll actually automatically get notified when new episodes get uploaded to our iTunes channel. So it's pretty easy, pretty simple.
Okay, good.
Yeah.
All right. Well, that does it for me.
I was going to ask you. I was going to ask you a quick question because this comes up a lot. I'm involved in a bunch of nonprofit volunteer organizations, and I'm assuming what you spoke about today would still apply to in that situation.
Well, what are you speaking of? The band?
Well, the whole topic of harassment or.
Well, remember, it's got to be an employer. So if it's an employer, somebody's being paid for what they do. Mm-hmm. And then the second requirement is that it's got to be an employer with at least 5 or more employees. Anybody with less than 5 employees, it wouldn't apply. So those are the two things.
What if they're all?
By the way, Rick,
from the top.
Excuse me. Your pictures, yours, not mine, but your picture's freezing up, so sometimes it's hard for me to hear you.
Okay.
Okay, go ahead.
What about volunteers from the top down?
Well, if you're a volunteer and you're just working for somebody for free, you technically don't fit the requirements. But let me put it to you this way: you'd have to show in some way that you have a relationship, an employment relationship, because these laws are based on discrimination in the workplace. And while you might be able to fashion some other claim for being mistreated as a volunteer, you're going to have a tough time saying you're an employee and therefore making these laws strictly apply. Remember that people can discriminate against other people all they want in a private setting. I can come up and call you any name I want or discriminate against you in any way I want. Now, if I'm renting you a house, for example, I can't discriminate against you because you're brown skinned or you're Filipino or you're black or whatever. I can't do that. But that's a different part of the statute. So when you're in a volunteer setting, you're going to have to be subject to what other people might not be subject to. You're going to be in a situation where you might be discriminated against, but then again, there's no employment relationship that would affect the workplace. I would look to other causes of action if I was in that situation. But there's a fine line between a volunteer and an employee. For example, you may be volunteering and you may not be getting actual wages, but you may be getting other benefits in lieu of wages that you might then claim qualifies you as an employee. So the best course of action is not to do this stuff in any kind of an atmosphere where people are working together. That's the real bottom line.
Yeah. All right. Well, thanks for clarifying.
Yeah. So we're good. We'll be back in a couple weeks, folks, and we'll have a different show or new show. And in the meantime, be prosperous, stay safe, wear your masks, social distance, all that good stuff. Vaccines are on the way. And we'll see you on the flip side, right?
Yep, you got it. We'll see you back here on that would be 23rd, correct? Tuesday the 23rd.
We'll post it. We're not sure yet. I'm not quite certain if I have a conflict on the 23rd, but you can always look at us on Facebook for the posting, and then I post on LinkedIn and on Twitter and so forth. So you'll always be able to find out. It's typically every 2 weeks, but you want to check the post to make absolutely sure.
Yeah. All right, Bill, thank you very much for the episode. And folks, we'll see you again in a couple of weeks. Stay tuned.
You got it, my friends. Take care.
All right. All right.